All right, good afternoon and welcome everybody. Welcome to today's webinar, Docketwise sponsored webinar, which is Best Practices for Removal Proceedings. I'm James Pittman, I'm co-founder at Docketwise. And I have with me two excellent lawyers who devote their practice or part of their practice to removal proceedings. I have with me Ahmad Yakzan from Florida and Moises Barraza from Illinois. I'm going to introduce them and let them tell you about their practice. We're going to be talking about a number of topics which have to do with sort of the essentials of removal proceedings. I mean, you may, as a practitioner, you may already be handling removal proceedings. You may want to, know about sort of insights that other practitioners have had about handling these types of cases, or you may be thinking about getting into taking cases of people who are in removal proceedings, and you may sort of want to know whether, or you may be thinking through whether it's the right step for you or not. So we want to highlight some of those and just give our insights and tricks of the trade, tips and things like that for how to effectively represent people in immigration court. So we're going to cover a lot of different areas, both practical and sort of substantive legal. So let me introduce Ahmad Yakzan, who's from Florida. Ahmad, tell me about yourself, your practice, and how you got into immigration law, and why do you take removal proceedings cases?
Thank you so much for having us. This is absolutely fantastic. I use Docketwise as my system for immigration forms, and it's fantastic. I actually am originally from Lebanon, came here in 1998 on my own. I was 18. I went through the F1, H1B, green card, and citizenship. I started practicing immigration law when I was still a fresh graduate from an LLM program at Stetson. And then the first case I ever won was in removal proceedings. And I loved it ever since. If you get to be, those are the cases where you really get to be the litigator in immigration law, unless you want to take federal, federal court cases too, which I do. I kind of empathize with all of my clients because I've gone through the process myself. So I know how hard it is to be in removal proceedings and what that means. I mean, it might mean you killing your American dream and having to go back. So that's why I really absolutely love them, and I love doing removal cases because I get to litigate, and the motion practice and all these things is what I really absolutely love doing. Not that I don't love doing other stuff, but removal proceedings have a special part of my heart because that was one of the first cases I have ever won. So.
And I also found that it's one of the aspects of practice that makes you really feel like a lawyer. You're not just in the office, you're actually going into court. The stakes are very high, and you really have to. I mean, it's an adrenaline rush, right? And it's also an area where you have to really do strategic thinking. So it's a very rewarding area of practice because people, by and large, are extremely grateful for you when you can help them. Unfortunately, sometimes if you have cases where people have very little means of relief available, you get the other side of it, and it's hard to see people get removal orders. Moises, tell me about yourself and how did you get into immigration law, and why do you take removal proceedings?
Hi, so yes, again, thank you for having us here. Just really excited to share about this topic of removal proceedings, and I'm very passionate about removal proceedings because of the high stakes involved. Kind of like you involved. I do a lot of asylum cases, and over the years, it's really kind of developed this like a philosophy of lawyering and kind of really what America is all about. You think you look at the Statute of Liberty and give me your masses yearning to be free, and that's really the heart of why a lot of people come to this country. A lot of times, they're fleeing violence, they're applying for asylum, or they're looking just for a better life, and that spirit, the human spirit that wants something better and is willing to take a risk to make life better for themselves and for their family. It's personally very inspiring. I mean, it's kind of my story as well. That's how I ended up being born in the United States. My parents took that risk to come to the United States and to go through the process, and now here I am, and serving immigrants. And really, from my first or second year in law school, I ended up, with an immigration internship, And at first it was very frustrating because it was a lot of, kind of grunt work, detail work. I was like, what's the point of all of this? This is so nitpicky. But then when I saw the difference that it made for the people that I was helping, it just clicked for me, and I haven't sort of gone back ever since. I've been passionate about immigration law throughout the years. I've been kind of starting to specialize my niche a little bit. I'm really kind of focused most in family and humanitarian and removal defense, and then even within that, I'm really, really passionate about intake, which we were kind of chatting about from the beginning. I just think it's so important to have a solid intake process, to have good strategy from the very beginning, because the way a lot of times a case starts will determine how it's going to finish. So.
Yeah, that's a really important point. Let's just talk about that now, since you brought it up. I mean, as a lawyer, you want to be thinking about the interplay between filing for immigration benefits and the shadow of the deportation system, the removal system. And you want to be thinking strategically about, whether, first of all, does your client have any grounds of deportability or removability in their background? That's, you have to do an effective intake in order to determine that are there violations of the immigration law in a potential client's background. And secondly, for the benefit that the person is seeking, is there, if the case is denied, if the case is not successful, is there the potential for the person to be put in removal proceedings? So to our guests, either one of you, how do you go about doing that? I mean, let's talk a little bit about some examples of how you maximize your intake so that you can catch these sort of things. Judith, the last thing you want is to start out, we were talking about this right before we opened the webinar, is that you might start out with a case that looks like it's a straightforward case seeking a green card or seeking some other benefit, and here the person has something that they didn't tell you about and they end up in removal proceedings. And that's bad for you as the attorney for a variety of reasons, and obviously bad for the client. So how do we not get into that situation, and how should we be thinking about our intake and the interplay between the systems?
Ask a lot of questions during the intake. I mean, my intakes are 30 minutes, and I literally go through every single question on the application in my head and make sure that sometimes you want him to end up in removal proceedings. I have a case, for example, a Cuban Adjustment Act case where she was denied 15 or 20 years ago, and the law changed, and I know I'm going to go fight it before USCIS in Tampa and make my argument that the statute does not make her inadmissible. And then knowing that at the end, they might not buy my argument. I might end up going in front of an immigration judge and telling the immigration judge and trying to convince the immigration judge of my point. Some of those cases you probably, want to have the long-term view of it. Am I going to end up with removal proceedings, and do I think I'm going to win it? Honestly, when I started practicing, I got those curveballs, 2 weeks in or 2 months in after I prepared the case. I had a J1 visa and I needed a 2-year waiver, right? So now I ask all of those questions up front, and my intake process is such that we ask all of those questions before they get scheduled, for us to know if there are any issues, for me to know how complicated it's going to be and how much ultimately I'm going to charge for the case. So asking all the questions, almost every single question on the application in that intake process will probably be a very good thing for people to do.
And Ahmad, you made an important point, which is there's sometimes where your client might have a greater percentage chance of getting approved in front of the immigration judge. Like, for example, with asylum cases, I know historically in a lot of the asylum offices around the country, the approval rate is significantly lower than the approval rate at EOIR. So I can remember only cases that had very, very clear, very strong supporting evidence and a clear claim would be approved on the first at the asylum interview. Everybody else, they referred over to the immigration court. And actually in the immigration court is where there are some advantages. First of all, you're in front of a neutral arbiter. Your judge is a neutral or is by the law supposed to be a neutral, rather than the case being decided by DHS. You're in front of the Department of Justice And second of all, in the court context, you can actually present live witnesses. You can cross-examine, you can present live witnesses, and present a much fuller case than you can do if you're sort of just at the asylum interview or an adjustment interview. Moises, you want to add about sort of the interplay between these systems and how you do your intakes?
Yeah, so kind of to piggyback off of what Ahmed was saying about asking a lot of questions. Throughout the years of kind of knowing your client base, knowing scenarios, and also sometimes running into issues where the client answered a question in a specific way because they had a different understanding of it, and then it turns out that their answer was wrong because they just kind of misunderstood the question. And so I think just as important as asking a lot of questions, it's asking the right questions in order to try to get to really what you're trying to get to. One of the things that I've realized throughout the years, for example, with certain issues like expedited removal orders and false claim to citizenship, which can have pretty drastic consequences for affirmative cases, especially, is that clients don't always understand. And a lot of times, there are some cultural nuances. For example, the majority of the clients that I serve are Hispanic. They're Spanish speaking, they're of Mexican descent. And culturally, when I ask certain questions, they tend to give a specific answer, and it's not always the right answer. And so throughout the years of kind of like getting to know them and getting to know what's their mentality, how they answer, how they understand the question, kind of getting inside their minds, it helps me start to sort of lead them little by little, breaking up a bigger question into a series of smaller questions that are trying to kind of screen for a specific issue
of that.
So a big one, U visas, right? U visas are like the magic carpet of immigration law. They'll waive almost pretty much anything. And a lot of times people have the permanent bar, they have false claim to citizenship, et cetera, et cetera. But whenever I ask clients, hey, have you ever cooperated with the police? The moment, at least the clients that I serve, the moment they hear police, their first answer is police, bad, not in trouble with the law, no, right? And so it's usually not enough, to say, hey, have you ever cooperated with the police? You have to kind of, hey, have you ever been the victim of anything? What happened? Did you file a police report? Did somebody else call the police? And then you start to lead them, because for whatever reason, I found throughout the years is that they're afraid. The moment they hear police, they're afraid, and they say, no, I have nothing to do with the police. No, I've never been arrested. They're answering the question in their minds that they think you asked, but really you asked a different question. A lot of times with false claim to citizenship, it tends to be the same issue. Have you ever falsely claimed that you were a citizen? No. And that's a really sad one, because a lot, it's one of those laws I really wish wasn't there, that we could really change, but it is what it is, and we have to screen for it. And a lot of times I have to break it up into smaller questions like, where did you work? When did you work? What did you use to work? Did you fill out any paperwork in order to apply for that job? When you fill out that paperwork, did you present the fake green card? Did you present a fake social? Have you ever worked without the fake green card? And a lot of times that leads to whether or not there has been a false claim to citizenship. And the other thing I wanted to mention is sometimes clients' memories aren't the best, especially if they've been here for, decades. They might not remember. And just honestly, I had a situation where a client honestly didn't remember that he had a border arrest. So I also think that doing your own background checks and documentary checks to verify what the clients are saying is equally important, right? Because whatever clients are saying may or may not be true, may or may not be a fact. And it's not that they're trying to mislead. Sometimes they just honestly misunderstand, or they just don't remember. And so that's one of the reasons that I'm so passionate about the intake process, is because, again, it really goes back to the intake, how the case starts, what understanding you have of the case and of all the possible issues and all the possible solutions. That's the only way you can really give clients, the best strategy and the best chance of success. And that's something that I'm just so passionate about. It's just that intake, that beginning process. It's another reason why I'm so grateful for Docketwise, because it makes it easy. Once you really screen the client, you have the strategy. The implementation with Docketwise is just, smooth in terms of the forms and everything. So
thanks very much for that. Let's set a little bit of context. So when we're talking about removal proceedings, we're talking about being in an administrative court, basically, which is part of the Department of Justice. And your judge is basically works for the Department of Justice. Your opposing counsel is going to be the ICE trial attorney. So ICE, Immigration and Customs Enforcement, part of the Department of Homeland Security. So the ICE trial attorney is representing the U.S. government. They are going against you and your client in front of the judge who works for the Department of Justice. And let's talk about a little bit the difference between the fact that the immigration court is an administrative court versus being sort of like an Article 3 court of general jurisdiction. Do either of you have any insights on how it's different being an immigration court versus being in, criminal defense court or in civil court?
Yeah, actually, I was one of I'm a member of the FBA, the Federal Bar Association, and they do a lot of work trying to change it from being under the DOJ to an Article 1 like a bankruptcy court or an Article 3 court like the district court. I don't know if that's ever going to happen, but I think moving it to an Article 1 court, I think will be a very good thing, because then you're going to have the rules of evidence and all these things that really help your client. I mean, the issue of it being an administrative, the ABA did a study a couple of years ago about the structure of our immigration system and how unfair it is, and how almost every single immigration court has an ACC, the Associate General Counsel downstairs. In Orlando, it's on the first floor, and the court itself is on the second floor. So people being so close to each other, that affects the fairness and the fairness of the proceedings. The judges being in the same building. Those are the things that the immigration bar has been moving, trying to actually change. But I don't know if it will ever change, because again, an immigration court is very complicated, but also the system itself is a little unfair to the immigrant. And that's why, as an advocate yourself, you try to kind of put your client on the same footing as the government, because one of the worst things that could happen is that the weight of the American government is coming at you, and it's really scary. And going there by yourself is also a very scary thing. I'm really amazed that people go through removal proceedings on their own sometimes, because sometimes they can't afford an attorney. So the difference between us being under DOJ, and again, I mean, immigration judges, with all due respect, are not even ALJs. They're actual lawyers appointed to hear cases. They're adjudications officers. Pretty much, they're not judges. So moving it even to an Article 1 court compared to an Article 3 court, which I don't know if I don't think it's possible to be an Article 3 court. I think the act of Congress will probably put it under Article 1 like a bankruptcy court compared to an Article 3 court. And that would take a lot of the injustice out. I mean, it's been really, like, compared to a lot of things, and with all due respect to judges that hear speeding tickets, it's like, I heard the saying before, like, you're pleading cases, murder cases in traffic court kind of thing. Because it's really akin sometimes to someone going back and getting killed, because I've had practitioners around here that actually have had that happen, where the person got deported and got killed afterwards. So that's not saying that the way it is right now is not a bad, is a totally bad thing. I mean, I think the fact that we don't have an evidentiary standard works both ways, because the judge is going to look at a piece of evidence, and you're going to argue the Fifth Circuit, the due process under the Fifth Amendment, confrontation clause, all of these things that doesn't allow a piece of paper to come in compared to, sometimes the ACCs don't even submit the evidence. And then you can make really good arguments regarding timeliness and all of these things that would keep it out. The problem, honestly, is you're batting against two pitchers, right? Like the judge can interrupt you, the ACC can interrupt you. All of these things are basic problems that could be fixed by moving it and giving the immigration judge a more neutral kind of role compared to what we have now.
Yeah, you've raised a couple of really important points. Is that in immigration court, the judge can actually question the witnesses, question the client, and so forth, which is way different from how it is in general jurisdiction court. The other thing was that the consequences, right? You mentioned doing murder cases or death penalty cases in traffic court. It's a funny analogy, but the truth is that the stakes are huge, and also the use of detention. The detention in the immigration system can be prolonged. It can be used sometimes what seems arbitrarily. It can be used in ways in which all of the due process that we usually associate with not being arrested, not being locked up or deprived of liberty, sometimes can go out the window in certain ways. So, people who don't get bond in the immigration system can often be locked up for the whole duration of their case. So it's heavy stakes. Let me just mention a couple of practical notes. Is that actually some other persons other than attorneys are actually allowed to appear in immigration court. There are BIA accredited representatives who can appear and represent people in removal proceedings. Sometimes law graduates can appear if they're working under the supervision of an attorney. People who are not yet admitted to the bar, but they have to be supervised by an attorney, and they have to indicate on their notice of appearance, which attorney is supervising them. There is also an immigration court practice manual, which you must practice according to the specifications of that practice manual. That's available on the EOIR's website, and you should familiarize yourself with it. If you're an attorney and you're planning to take cases in removal proceedings, you do have to register with the immigration court. It's basically a two-step process. There's an online registration through the EOIR website where you submit, some information about yourself, and then there's a second step to verify your identity, which you can do either by appearing in person at any of the immigration courts or through an online meeting that you arrange ahead of time. Also, the immigration courts have come a long way in the last couple of years in terms of allowing online filing. The filing used to be done all on paper, and you used to either have to go to court and file things in person, or mail them into the court by postal mail. Now they have what's called the EOIR Courts and Appeals System, the ECAS system, which allows you to do a number of things online. It allows you to file your entry of appearance. It allows you to file motions, submit applications, submit evidence, download a copy of the record of proceedings, which is essential. Sometimes if you're taking on a case that's in progress, you need to download the record of proceedings and familiarize yourself with what's going on in the case before you've signed on to it. And also allows you to check the case status and see, when hearings are scheduled. There's actually two types of hearings in immigration court. Moises, you want to tell me about the two different types of hearings in immigration court and what goes on at each of them?
What are you referring to?
Like master calendar versus
individual
merits. Yeah.
Yeah. So one of the things that I've really appreciated recently is that you had to call in order to find out, what the date was and what kind of hearing, just to verify. A lot of times clients, they would get paperwork and they would say, oh, I have a hearing. And you're like, what kind of hearing? Is it a final hearing with the judge, or is it a preliminary hearing where you're just kind of telling the judge what you're going to do in the case? And so those are the two kinds of hearings, the master calendar hearings. And recently here in Chicago, they've been allowing a lot of telephonic appearances, which has saved an incredible amount of time. I live out in the suburbs, so it takes me, a lot of times in traffic over an hour to travel to court just to be in front of the judge at a master calendar hearing, which is a preliminary hearing for 5-10 minutes, discuss the case. What are you filing? Here's your next date, or if do you want an individual hearing? And then that's the other kind of hearings, individual hearings, which are the final trial essentially before the judge. I do appreciate that, at least here in Chicago, they've been allowing attorneys now to appear telephonically for the master calendar hearings. The last couple that I did last week were like 2 minutes long, and literally, you want an individual hearing? What are you filing for? Great, here's your date. We're done. That's been a positive development, from the unfortunate worldwide pandemic that we've been suffering, and as courts have been kind of trying to balance how to deal with the backlog and the logistics, which is a whole nother issue. I think that's a whole nother important topic, which is the logistics and the political winds. There will always be sort of the more restrictive and then the less restrictive, and I think that's an important consideration when having a removal defense practice is how many cases are you going to take, and how are you going to make sure that you're on top of the cases that you have taken, and what happens when the politics change and all of a sudden you're taking 2 or 3 times, you're spending 2 or 3 times as much time on a case than you initially anticipated. Are you doing flat fee? Are you doing hourly? I think those are also very important considerations for removal defense practitioners.
Well, let's talk about some of these practicalities. I mean, certainly you have to have a retainer agreement where you spell out how you're going to charge the client. What's, to our guests, I mean, either one of you, what's your experience with, are you doing removal proceedings on a flat fee basis? And just in terms of how would you formulate the fee? I'm not asking you to give us your fees. I'm asking you how people should think about, lawyers should think about how to determine the fee and what basis to calculate the fee. What sorts of things do you put in your retainer agreement aside from a statement of, of the services and the fees that you're going to charge? What else should go in your retainer agreement? And what types of expenses in the case do you occur with your typical removal cases, and how do those get paid? Anyone?
I think one of the things that immigration lawyers do is that they don't charge what they're worth. A typical,
heard that before.
Yeah, a typical removal case of probably if you're doing it correctly, it's going to take you to 30 to 40 hours to get done with. And so charging $4,000 or $5,000 for a case that's going to take you 40 hours to do, and after you pay your staff and you do all of that, you're getting paid $5 an hour. So I have a minimum amount that I charge that I'm not going to say on the seminar. And then I go up from there, depending on what it is that I'm having to do. I also have to explain to clients is that removal cases are different from the case. So if you have an I-130 that you can file just because you just got married to a USC and you want to go get an I-130, I'm going to charge you a different amount of money for that because clients believe that it's all inclusive. So I have become actually better at delineating that in my agreements, putting benchmarks on what it is that I'm charging and how many hearings do you get. You only get one individual hearing. If I have to go to additional ones, you're gonna pay me more. So a part of it is really internal to the bar, and us as immigration practitioners, again, I mean, we're defending people's lives. We're not just doing paperwork. We're really, I mean, a brief is gonna take you 10 hours to write if you're doing pre-hearing briefs before you go in front of a judge. So again, that's about $3,000 worth of your time when you're charging $5,000 for a case. And either you get a good lawyer who's going to give you the individual attention, or you get the $5,000 lawyer, and again, nothing against people, which actually get that are not going to give you the attention that you deserve. The other part is, are you going to get paid in advance, or are you going to get paid take payments? I don't take payments in my practice. I get 2 payments. I get one upfront and one before I go to the individual hearing, and they're not refundable. I start working on the case right away. So these two things, if you want to put people on a payment plan, are you going to charge them monthly? What happens if they don't actually if they don't actually pay you? What happens in a detained case where your client gets deported and you didn't get paid in advance and you did all of this work for free, right? I mean, we're lawyers, we're bleeding hearts, we really want to help immigrants, but we also run businesses. So all of these considerations are things that you really have to think about before taking on cases. Do you have the time? Am I gonna make this profitable? I mean, as a businessman, you have to actually have that as the number one thing that you think about. So all of these considerations you have to take before you take on removal cases.
It's absolutely true. If it doesn't, I mean, if you don't have a roadmap for how it's going to work economically, you shouldn't do it. And you should be prepared to change tacks if you find that what you're doing is not working and you're not making it economically feasible. If you just want to do removal proceedings and you just absolutely don't know how to make it feasible, then maybe you should be working at a nonprofit rather than trying to do it in a private office where it's not going to, it's just not going to work. Moises, you want to join us on that topic? How do you handle formulating fees?
Sure. So prior to COVID, prior to the previous administration, when things seemed a little more stable in terms of expectations, in terms of you kind of had an idea when you took on a case of what, you know, how much time you would spend on it, when you would get an individual hearing. So back then I used flat fees. You know, the majority of my work is flat fee based, but as a result of the previous administration and then COVID, you kind of compounding it, turning what used to be a set strategy, a set process, a set at least within, you know, a certain time frame, you know, it turned it into, it kind of flipped it on its head, you know, and all of a sudden I had 2 years of all my individuals getting canceled, all my masters getting canceled, you know, a lot of issues affecting, you know, the asylum process and all of my asylum clients that I've been representing. It really forced me to rethink, am I going to make it financially if I keep taking on these cases? And I'm guessing, you know, I'm increasing my flat fee, but I really don't know. I don't know how long it's going to take. When is the next individual going to be scheduled? I think one of the biggest issues for me was, you know, whenever an individual is getting close, it's usually crunch time for me. We're training the witness. We're making sure that the expert is ready to go. We're making sure that all of the evidence is up to date. We're spending a lot of time to make sure that for that individual hearing, everything that we are presenting is current. But what happens when all of a sudden you get all of your hearings canceled? When now all that work that you did to prep for all of your individuals is stale. And if it gets scheduled 5 years down the road, the judge might say, well, counsel, all the evidence you presented was from 5 years ago. I have no evidence that the country conditions are still the same, or, you know, whatnot. And so that really kind of forced me to go hourly. And so now what I'm doing with my removal defense cases is I'm doing them hourly. And, you know, I've heard it said both ways, you know, that there are pros and cons to both. For me personally, I have the certainty that I'm at least billing, you know, for the time that I'm actually investing in the case. I would probably guess that most immigration practitioners underestimate how much time a case is going to take. And so with the hourly, you're at least billing. Now, collection is another issue, right? How are you actually going to collect? How are you going to explain that to clients and get them to understand what it means, you know, to be billed hourly? But so far, you know, with at least with having a trust account where they can, you know, put a lump sum or deposit, you know, on a regular basis. At least, you know, like, okay, well, there's a savings, and I can be withdrawing from that savings. And I know that at least as I'm working on the case, I'm getting paid for the work that I'm doing. So at least for me, it gives me a little more peace of mind knowing I don't have to be worrying about the finances. I'm just worrying about winning the case. And that's very important. You never want to be, as the individual's coming up, you never want to be, shoot, I'm spending too much time on this case, I'm going to lose my butt on it. You just want to be mentally focused. What do I have to do to win this case? So at least for me, it really helps, to go hourly.
It's a really important topic. I mean, flat fees, the whole idea of a flat fee is you already know approximately how much time the work is going to take and what's involved in doing it, and that allows you to calculate the flat fee. Hourly really is often used in litigation, and that's where it's open-ended and you really do not know. And I definitely can see the argument for doing it on an hourly basis. I just think that when you're dealing with, the problem with the hourly, it always seems to me, was the kinds of clients that you're dealing with a lot of times in removal proceedings are not used to being billed hourly for a service. And so there's a gap of understanding there. And I mean, are you finding though, it seems you're saying it's working out for you, are you finding that are you actually logging all the time that you're spending, you're actually billing pretty much all that time? And they're understanding that's not causing huge problems?
I think it definitely took me a while to sort of change my mentality and explain it to them in the right way. I think the general sort of client objection to hourly is, what does that mean every time, I talk to you on the phone? Now I, as a client, I'm worried about, how much is this costing? And so it definitely takes a little bit of explaining to the clients of why it's hourly, why it's fair to both sides, and why ultimately that will give them the best chance of success, right? On the, making sure that their finances are in order for their case ensures that the attorney is focused solely on the case, not focused or worried about, am I spending too much time on this case, or can I afford to do this, that, and the other to try to win? And of course, as ethically, right? Ethically, we have that duty. It doesn't matter how, if we're overspending or, paying the client. Once we accept the case, we do have an ethical duty. We have to do what it takes to win. We have a duty to competent representation. But I think on a human level, it's distracting when we don't know if we're financially, paying them to take on their case. Maybe we've paid our staff so much, we've spent so much on expenses that we're literally paying them. I actually heard a colleague mention that he did a financial analysis, and this is why I think keeping track of time is important even for flat fee cases. But he did a financial analysis of his citizenship cases, and after he totaled up his time and his staff time and everything that he was spending in it, he was like, I was literally paying every client walking in the door $200, for me to represent them on a citizenship case. And this is what can happen. And it's so easy, right? Because as attorneys, we have so much to think about, especially as solo practitioners. We have a million things to worry about. And a lot of times doing the ROI analysis, like Ahmed, mentioned, like that is just essential. You can't run a business if you are not tracking your ROI. And that's kind of what hourly does. Well, you're building it into the way that you're billing the client. That you're going to get paid what you're worth. Your staff is going to get paid. Your overhead's going to be covered. As long as, and I think this is the secret, as long as you can get the clients to understand, why you're doing it and why it's fair. And of course, not everyone may agree. There will be some clients that ultimately they're like, no, I'm sorry, I'm just going to go, somewhere else or whatever. But at least for me, it's worked out pretty well. And it did take some time to kind of find out how to explain it.
And don't underestimate the amount of incidental expenses that you can run into in removal proceedings, because when you're producing large filings and you're having to produce 3 or 4 copies of those, you're talking about office expenses, you're talking about ink, you're talking about toner, you're talking about shipping costs, you're talking about travel of to and from the court. All of that, it has to be factored in, really. And also, I think I'm of the opinion that retainer agreements for removal proceedings have to be significantly more detailed than they would be for affirmative cases in a lot of instances, because you do have to consider what the various contingencies are. What happens if you know, you need to, I mean, you need to explain that the appeal is separate. You need to explain that it doesn't cover an unlimited number of hearings. We're predicting this many hearings, but you know, if there should be more hearings, that's going to run into additional fees. There could be changes in the law which result in the need to do something else or do something extra. There can be any number of things which affect the flow of the case and the total amount of time and effort that you're going to put into it. And to the extent possible, I think all those contingencies, you should attempt to state those in your retainer agreement, especially if you're doing it on a flat fee basis. Now, if you're doing it on an hourly basis, then, you know, again, no matter what you do, it's going to be covered. So those two items. Ahmed, if you're litigating in federal court, are you still doing that on a flat fee basis? Ahmad?
I'm sorry, James, I lost you there for a second. I don't know if everyone can still hear me.
We can hear you.
Yeah, I'm sorry. What was the question again?
Oh, there you are. You're back. I said, if you're litigating in federal court, are you still doing that on a flat fee basis? I think he's having a little tiny bit of issue with his Wi-Fi or something. Okay, so I think he's going to come back in a second. Yeah, all right, so let's move on to the next topic. Now, I want to mention commencement of removal proceedings. So there's actually two sections of the Immigration and Nationality Act that have to do with charges of removability. One of those is INA 237, which spells out grounds of deportability. Deportability would be when somebody's already been admitted to the United States and then they commit an offense specified in section 237, they can be charged as deportable. So deportable means someone's been admitted to the country, but they're removable because they violated the immigration law. The other section is INA 212, and that's inadmissibility. And that one applies when somebody is coming into the United States, they're applying for admission to the United States, and they're found to have one or more grounds of inadmissibility. So you were dealing with two different concepts. So let's talk about the various ways that people can, we talked a little bit about the various ways people can get into removal proceedings. There can be denied applications. Asylum, for example, is a kind of a fast track to get into removal proceedings. You know, a case if you file affirmatively for asylum, if you're not approved right at the asylum office, the next thing that they do is a referral to the immigration court, and your client's placed in removal proceedings. Criminal convictions and arrests are certainly a big way that people get into removal proceedings. Let's have our guest talk a little bit about that. How do criminal convictions or arrests come to the attention of the Immigration Service? What are some of the common routes for clients getting into removal because they were in trouble with the police?
I'm sorry, guys. I got kicked out, and
it's okay. You're back.
I'm sorry to give this lawyer answer, and it really depends, right? The fingerprints are very important. So if you come to your attorney and you actually lie about having a conviction, the FBI is really gonna know that you have a conviction, and because they probably run it. If you're coming from overseas, or if you've come from overseas, they're gonna run the Interpol backgrounds and all of that stuff. So ending up in removal proceedings can take so many ways. I mean, with 204 Gs, you can end up getting arrested for for a small parking thing, or getting into an accident, which in the last 4 years we had this so many times. You get in an accident with another driver and you end up in removal proceedings because of those. It really also depends on how ICE and your local sheriff actually work. Do you have those agreements, or you don't have those agreements? So one way is for you to get arrested, you end up in removal proceedings. You can also get arrested by submitting an application that you shouldn't have submitted. Sometimes you go to a notario, and a notario applies for an asylum case for you, but guess what,
Moises, you want to chime in while he's frozen there?
Sure, yeah, and that is a big problem of the unauthorized practice of law and filling out applications. A lot of times they'll promise, you know, an employment authorization, and oh, I'll get you an employment authorization, and they're filing. I think Ahmed's back. They're filing asylum applications.
Go ahead, Ahmad.
Go ahead,
Finish your
Moises.
thought. Either one.
And then they're just, you know, promising the asylum applications, you know, or promising employment authorization, and they filed a frivolous asylum application, and then now they're in the deeper hole than when they started, and all of a sudden the notarial disappears. And so it's another reason why I'm so passionate about intake and trying to make intake, you know, really accessible to as many people as possible. Because if it's not, that's when they start going to, you know, the notarios or the tax preparers. It's a huge problem here, at least here in Illinois. A lot of the tax preparers are saying, oh yeah, I'll file this or I'll file that. And it's a really big issue with the system, because, you know, the system, and I always explain this to clients, it's not set up to really screen eligible people from the beginning. It's set up to take money and to issue a receipt. And as long as certain requirements are met, whether or not they are legally qualified for that benefit, you know, the client starts thinking, or the applicant starts thinking that, oh yeah, they looked at my case, they issued a receipt, that must mean that this was done right. That must mean that I qualify. And that's why, you know, notarios kind of take advantage of that system. And once the clients, you know, sees the, you know, the receipt, or they get the employment authorization card, they assume, oh yeah, he's doing great. And then they start telling their friends. And then before you know it, you have, you know, a large group of people being taken advantage of, you know, by the notarios, because they're taking advantage of this system that really does not legally qualify the case, you know, from the beginning. They only do that at some point later on down the road. And then that's when they eventually run into issues. And now when they come to us, you know, sometimes, you know, us immigration attorneys, sometimes we can help them, but sometimes their hole's so deep, we're like, you know what, it's too late now, you know, and that's really sad. It's really sad to see. And you know, most of the cases, it's not too late, but there are a few cases, there are a few instances, and it just breaks my heart to say, I am so sorry. I wish you would have come to me from the beginning. We could have saved you this issue, and now there's very little that we can do. So
yeah, sometimes it's really worth doing a FOIA on the client's A file if you can get, especially if they're already in removal proceedings. At least it used to be the case that if they're in removal proceedings, you could get the FOIA a lot quicker than you could otherwise. There used to be a track 3 FOIA. I assume it's still that way. But getting a FOIA, and definitely if you've already entered an appearance, downloading the record of proceedings and thoroughly reviewing. Ahmad, did you want to add anything else about ways that clients can get into removal?
I mean, it doesn't really matter the way they end up with removal proceedings, as long as they're honest with their attorney. Because there are a lot of ways to defend them. But if, I mean, there's still, again, as I was saying, you can get arrested, you can commit marriage fraud, you end up with removal proceedings, you could lie on an application that made you ineligible for the benefit before, and now you're applying for citizenship, and they catch the lie from, you know, that you committed on your green card application. Now you commit a misrepresentation and you end up with removal proceeding that way. That's actually one of my favorite cases. I ended up defending it for 7 years, going back and forth to the BIA, and I had one of those cases. So it really, there are a lot of ways that actually can end you in removal proceedings. I think the worst one is going to a notario and ending up in removal proceedings because you went to a notario, because and I know these people are most of them are crooks, and they take money when they shouldn't, and they apply for things when they shouldn't. And my biggest advice, and I don't know who would be looking at this webinar, is go to a lawyer, because they're gonna know what to do. Don't go to a notario just because a notario is gonna charge you 1/5 or 1/10 of what the lawyer is gonna charge you.
Absolutely. Let's talk about notices to appear. So immigration proceedings in immigration court start with the Department of Homeland Security filing a charging document, which is called the notice to appear. in the immigration court, and then the immigration court issues a hearing notice for a particular date and time and sends that out to the respondent. Now, the notice to appear has certain sections to it. It has allegations and it has charges. And when you're representing your client, you are going to be asked to plead. And to plead means to either admit or deny an allegation or allegations, and then to admit or deny the charge of removability. So let's talk about some ideas about how to plead, whether to ask for attorney prep time, whether it's better to just plead, whether you plead on paper. You can sometimes plead on paper to the allegations in certain circumstances, and how you determine whether you're going to be admitting or denying the charge of removability. Either one of our guests?
Sure. I mean, I think when it comes to pleading, I've heard different sort of philosophies. One philosophy is make the government do their work. They have to prove, depending on how the burden is, at least at the start, there is some burden and they do have to prove something. A lot of times the government will present the I-213, and some allegation of alienage or country of origin. And so that, they'll prove alienage, when they're starting, and then they'll charge them, as being present without admission or parole, et cetera. And so one philosophy is deny everything. And I remember a colleague, saying, I did that. And at first, they hated me. The immigration judge was like, what are you doing? And this colleague just kind of patiently persisted and said, I'm just doing my job. I'm just representing my client. I'm making sure that we're following, everything, we're following the rules. And if the government has a burden, then they have to meet it. I think that is one philosophy. It is not one that I personally use. A lot of times I'm looking at the end goal. I'm trying to see, well, what is the end goal? Is the end goal to apply for relief that is very strong? If that is the case, I'm not gonna fight the allegations. I will admit the ones, and of course make sure that they are correct. Yeah, as sometimes there are mistakes in the allegations. But for me, a lot of times the end goal, or is this one of these cases? I had a case in which this was very soon after the Supreme Court came down with Pereira, and everyone was kind of speculating, well, what's going to happen? The date and time have to be included in the NTA, and at least in the Seventh Circuit and in Chicago, we were able to to fight the fact that, or to bring up the issue that, hey, based on the statute and based on the Supreme Court's interpretation of the statute, this NTA is not an NTA because it does not include the date and time of the hearing. And so therefore, judge, you have to terminate proceedings. And we did, at least at first, we had a few cases that were terminated. I had one particular case that's kind of a cool story about that, because the client was applying for asylum, was probably looking at years and years, of wait time in court to apply. We ended up terminating, filing with USCIS affirmatively, and then winning the case, much quicker. And so that was one story that it kind of shows the importance of doing your homework and reading the NTA. And obviously, the attorney that brought this up to litigated it all the way up to the Supreme Court, he read the statute. And that is also something, I think, a best practice, especially in removal proceedings. A lot of times people just assume, well, this is the way it's always been, so that's the way it is. And all of a sudden someone comes along, reads the statute and says, well, we're doing it wrong. And you've been doing it wrong forever. And we're going to challenge that. So definitely looking at the statute and what is required in the NTA, can be something to look for if you're interested, in my opinion, if you're interested in sort of litigating every aspect of the case, or prolonging the client's presence in the US. And again, to me, a lot of times it's more about what is your end goal. If the NTA is defective, maybe you might raise a footnote. NTA is defective. We're not gonna litigate it too much. ultimately we want to apply for asylum. So I think it just kind of depends on the philosophy of the individual immigration attorney.
Yeah, it does. It depends, and it depends on the circumstances. I mean, if you deny an allegation, be prepared for the judge to ask you, what the allegation should be, or what you are alleging. And if you deny the charge of removability, then it means that you need to have a contested hearing on the charge of removability. You say that the charge as stated is denied, then you are putting ICE to their burden. So the court then has to set a hearing, and sometimes they might do that immediately, although normally there's a separate hearing. You have to come back for a hearing on the charge of removability, in which the government has to present the evidence, put the evidence in the record. And if they don't do it by the hearing date, then you can seek termination. I mean, I actually had that happen with a case of someone who was charged with a very serious crime, which would have been an aggravated felony and would have essentially barred all relief. But the Immigration Service actually lodged 3 separate charges of removability, and it was set over for a contested removal hearing, and they did not put the evidence in the record by the date, despite having had every opportunity to do that, they simply did not substantiate the charges of removability as written. And I sought termination, and the case was in fact terminated. Now, had they done their job, my client might have been looking at a very different outcome. So you do have to, and then if if you are going to, let's say, apply for asylum or something, or you're renewing the asylum application in front of the judge, and they're just charging that the person remained longer than their authorized period of stay. Sometimes there is no point, really. There is no practical point in denying the charge if, in fact, that ICE can substantiate that. And if your end goal was to get to the form of relief anyway, in that situation, your best bet might just be to concede the charge of removability and move on to the relief stage. And then the next question that the judge will ask you is, what form of relief are you seeking? So let's talk about applications for relief in removal proceedings. Some of those include asylum, right? So asylum can be either a renewal of an asylum application, I-589, that was originally filed affirmatively with the USCIS, and now your client has a second chance to have their asylum claim heard in the immigration court. Or they also sometimes may have applied for adjustment of status, which is denied. And sometimes, depending on the circumstances, denial of an adjustment of status application does result in the person being put in removal proceedings. So they can have a second chance to have their adjustment application heard by the immigration judge. Other times you're filing applications that are specific to removal proceedings, and some of those include cancellation of removal for lawful permanent residents. It's basically a form of relief. It's essentially a type of waiver, right? The person is removable, they are deportable or inadmissible, but they are a lawful permanent resident, and they've been a lawful permanent resident for a length of time that qualifies them to seek this form of relief. That's an EOIR 42A. There's a similar application for people who are not permanent residents. That's called an EOIR 42B, and that's cancellation of removal for non-LPRs. That's quite harder to get. You have to prove the person has 10 years of physical presence in the United States. They have a qualifying relative who meets the standard of extreme and unusual hardship, or I can't remember the exact wording, exceptional and unusual hardship, and that they merit the favorable exercise of discretion by the immigration judge. So it's harder. It's definitely a harder form of relief to get. There are other waivers, like an I-601 waiver, which can be applied for in removal proceedings. And then don't forget that termination of proceedings is itself a form of relief. So let's talk about some of the other topics, like travel while in removal proceedings. Moises, do you ever allow your clients, or do you ever advise them that they can travel, or is it just a
no?
Okay.
No, it's definitely a no, and the question does come up from time to time, but they basically waive their rights if they leave while they're pending removal proceedings. You know, at least as far as I've looked into this, and so it's definitely something that's not advisable. You know, and
Now,
on the topic of removal proceedings,
yes.
I wanted to mention it's important to look at, you know, your sort of statutory relief for removal proceedings. And we were kind of having this conversation a little bit before we started, was that it's also important to have in mind, you know, to screen them, you know, for any affirmative relief, you know, that they might be eligible for. Because they, you know, at least in Chicago, a lot of times the judges, they like it when the client has affirmative relief because, you know, they're overburdened, they have so many cases, they can get the case off their docket, and a lot of times they'll either administratively close, or they will put them on like a status docket, or in some cases, you know, they will even terminate proceedings and allow the respondent to then apply directly before USCIS. And the judges like that because it's taking work off of their plates. So it's also important, and this is why I sound like a broken record, and I always say it goes back to intake, it goes back to screening. It's so important to have a complete picture of all of the issues and all of the possible solutions, so that when the client is before in a high stakes situation, such as they're in removal proceedings, they're about to get deported, they know what all of their options are. I think one of the things that I've been learning recently is that T visas are often under-screened for. It's not something that most practitioners, immigration practitioners, are aware of. In fact, but there are visas available, and most times the visas are not even completely used up. And that, I think it's important to as immigration practitioners who really want to give our clients the best chance of success and try to advise them, here are all of your options. It's important for all of us to get trained on something like a T visa, you know, that might be a form of relief for them. So.
Yeah, look for creative solutions for sure. I mean, I did have a circumstance that wasn't a textbook T case. It was a situation of a forced marriage, and we actually made the argument that the forced marriage, the person being subjected to a forced marriage in a foreign country and then subsequently brought into the United States, was a form of trafficking. That's not a textbook. You know, your textbook, what you think of most of the time with the T visa is someone, you know, is brought under false pretenses, and then they end up being trafficked into the United States. But this was a little bit different situation, but nevertheless, it fit in the T visa category, and we actually got that approved. The person subsequently became a U.S. citizen. So, but a couple of things to keep in mind, practically speaking. If your client can apply for as many forms of relief if they're eligible for, you don't have to just pick one. So you can have some in your back pocket. I mean, you can be seeking your primary form of relief. Best things are always things which result in the client becoming a permanent resident if it's granted. So cancellation of removal grants them a green card. Adjustment of status grants them a green card. You know, asylum does not grant them a green card, but grants them asylum status. But sometimes, you know, if your client is subject to a bar to asylum, like they waited too long to file an asylum application, namely they didn't file within 1 year of entry, then you're getting, you know, you may be seeking withholding of removal, which is stops them from being deported, but doesn't carry all of the benefits that asylum carries, and it also has a higher standard to achieve. And then Convention Against Torture is the other option there, which is you have to show that it's more likely than not that the person would be subjected to torture in their country, in their home country, by either the government or somebody that the government has allowed to basically, it's somebody acting under color of government authority. So you can have more than one, but be prepared. So once you state after pleadings, then if your client is found removable, the next question the judge asks is, what form of relief are they seeking? And then you state the forms of relief, and then you need to be prepared. You may have already made up the application and brought it with you to court on that day, and you can file it. But if you haven't, then typically what happens is the judge gives you a deadline for filing applications for relief, and you need to strictly adhere to those deadlines, because if you miss the deadline, the judge may pretermit the application, may consider that you've basically abandoned the right to file for that form of relief. So that's
I was just going to say that's a really good point, because a lot of times, even if ultimately, let's say, for example, cancellation of removal, EOIR 42B, right? It's a very high standard, as you mentioned. It's exceptional and extremely unusual hardship.
Right, there you go.
And so it's like that language is such a high standard that it's only going to be a fraction of cases that are actually going to be granted. But it carries the benefit of employment authorization while it's pending. So, if your client at least has a viable case, it's not like a frivolous case, it's got a viable case. Maybe it's not, a slam dunk, maybe it's not your winner, but you could file your EOIR 42B, get employment authorization, and then if your client has another perhaps stronger form of relief, you can pursue that. So that can, a lot of times be a strategy, and it helps clients too, because as we were discussing previously, with Ahmed, a lot of times clients who are in removal proceedings, depending on the situation, they may have a hard time finding a job and paying, and it's kind of like this catch-22 where they're in this high stakes situation. They really need the highest level of representation, which means they will need to put in a substantial amount of money. But if they don't have employment authorization, a lot of times they struggle with that. So for non-permanent residents, EOIR 42B, cancellation of removal, tends to be a pretty nice way to have something pending that's in the court, to get employment authorization, and of course, obviously making sure ethically that it's not a frivolous filing, while
Right.
you're pursuing something else.
That's right. And there's a big difference between a weak claim and a frivolous claim, right? You can't
Absolutely.
make frivolous claims, but a weak claim, not every case is the greatest. And removal proceedings take a long time. That's another thing you have to keep in mind, is it might be a year or 2 years. I don't even know what they're out to right now, but it was very common for it to be at least 1.5 years to 2 years between the time that you filed your application for relief and the date of your client's individual merits hearing. During that year or two, a lot of things can happen. Circumstances can change in the client's life. There have been cases, I've seen cases where people applied for a form of relief, and during the intervening time, they met someone, they got married, and there they had an adjustment case that could be. Now, of course, if that's a whole separate issue. If you get married while you're in removal proceedings, there's a higher bar to having a marriage-based petition approved. But nevertheless, it's possible to meet that bar. So I've had cases like that approved. So a lot can happen in those 2 years, and your goal is, to keep the client in the U.S. and keep fighting while the case is going on. The case might take a long time, and other things might come up that they can take advantage of in the meantime. I'd seen a number of respondents who, were in removal and they had a cancellation case going, but in the meantime, TPS was approved for their country, and they were able to get termination of proceedings. Now, administrative closure, is a great thing when it happens, and it used to happen a lot. Then there was a policy shift where administrative closure was made a lot more difficult. But typically, if people are in removal proceedings and the government says that people of their nationality can apply for TPS or apply for DACA or apply for some other status, they typically were able to administratively close those proceedings, and that's a great thing because it's out of sight and out of mind for as long as that lasts. And then down the line, they may have yet another form of relief. Moises, do you have any sense of how generous or not generous are they being with administrative closure? Has that improved since the previous administration, the Trump administration, made it very, very difficult for judges to administratively close case?
I mean, thankfully it has improved. Here in Chicago, judges are, and I honestly think the judges liked administrative, at least most judges liked administrative closure, because again, they are so overloaded with cases that whenever there's a possibility of other relief, at least here in Chicago, they like to set it aside and see if USCIS could take care of it. And so thankfully, yeah, we're back to kind of normal in terms of administrative closure, which is really, really, really good to hear, because it was very upsetting, when especially for clients that had ultimate relief. I had one case where the client would have been otherwise eligible for the I-601A, and he was already in removal proceedings. And it used to be the practice in Chicago that they would admit close, wait for the I-601A to be approved, and then they would go ahead and the attorney would motion to reopen and then terminate, and the judges were okay with that. But then after administrative closure stopped, with the AG referring the case to himself and saying there's no admin closure under the previous administration, that made things difficult for that scenario. And ultimately what the client had to do instead was he had to seek the I-601 outside of the US, which of course, it added a whole nother, life change that he wasn't expecting, and et cetera. So, but thankfully, we are back to normal in terms of the possibility of administrative closure.
Mm-hmm. Now, if you present your client's claim and you do get denied by the immigration judge, then you're faced with the possibility of an appeal. Appeals in removal proceedings are taken to the Board of Immigration Appeals. It's still part of the EOIR. And basically, there's a panel of judges that hear cases. Most of the time, the case can be heard. Case is usually heard by just one board member. Usually signs off on a decision. Occasionally, you may want to request oral arguments before the board, and then it's the board's decision whether to grant those. That's typically seldom done, but sometimes it's warranted. If they feel it's warranted, then they may agree to that request. If the board rules against you, then depending upon the actual ground that they ruled against you, you may be able to go into the federal circuits. And Moises, have you done any? I know Ahmed said that he typically handles those. Are you doing any circuit court review petitions or?
I haven't done too many, circuit court review petitions recently. I have done, some in the past. When it, if the IJ at first issued a removal order in the case, there's that automatic stay, with the BIA appeal. But the issue with the federal appeal is that there isn't. So then you have to apply directly with the ICE office for a stay of removal and try to convince them that while the appeal is pending, that they should allow, and it's not guaranteed that they will. So it's definitely possible, but it's definitely a higher risk that needs to be clearly explained, to the client that, even though we're fighting your case here, we're going to try to convince ICE to let you stay in the country. But, if they deny it and they come after you, you could be, removed. And so that definitely complicates things for sure.
Mm-hmm. And it's a lot of times, but the case law, the evolution of the case law is really in removal proceedings. It's really about what goes on at the circuits. Because the appeals are taken directly to the circuit level. You don't really appeal an IJ decision for removability to the federal district. There isn't jurisdiction there. It usually goes directly to the circuit court. So the various circuits are interpreting the removal statutes in various ways, and that's where you're going to find the case law evolving. And then occasionally something will make it up to the Supreme Court on a particularly important issue. Now, if you're, also there's a motion to reopen. There's both motions to reopen and motion to reconsider in removal proceedings. Motion to reconsider, you're basically telling the judge that they made the wrong decision, and you're asking them to reconsider the decision that they made, and you have to sort of point out where they were clearly erroneous. Motion to reopen, you're coming back to court after a removal order, and you're trying to open up the case again because something's changed. Either the person, you're claiming that the removal order, the person didn't have notice of the hearing and they got removed in absentia, or they, there's a new form of relief that they're eligible for and you're seeking a discretionary reopening. So you need to familiarize yourself with the motions to reopen. And sometimes that's how you're going to start. I mean, sometimes people will come to you who have a removal order and they're specifically seeking to reopen their case. And then there's also,
I was just going to say, I think that's a great point because one of the best practices that I think immigration attorneys can have is to know their circuit, know their judges, and know the local practices. I've done removal hearings, across the country, and this was years ago, and I very quickly learned not all immigration courts are created equal. You know, even if technically they're operating under the same, you know, BIA case law, the actual application of that law is a lot of times worlds apart. I had one situation once where I was litigating a case in El Paso, Texas, and literally it was an asylum case, and before the hearing started, the judge said, "I just want to let you know I have 100% denial rate on asylum cases,
Oh my goodness.
and I've never been overturned." You know, and that was very upsetting. And of course, and I was like, well, you know, I'm here to talk about the law and the facts. You know, I'm not here to talk about percentages. And I litigated the case, and you know, but ultimately, it was mind-opening to see how different it can be. You know, in different parts of the country, how different immigration judges will have a different take on it. Ultimately, you know, Ayla, you know, was very involved with addressing that issue, and you know, they did address it, you know, because that clearly shows bias, you know, if that's the mentality of the judge. But that is definitely one of the best practices, is if you're going to take a case that's outside of the region that you are familiar with, either find someone, you know, through the American Immigration Lawyers Association that is familiar to co-counsel, or maybe just refer it out, because it's going to be very different depending on where the case is at.
And I also want to mention post-conviction relief. I mean, if the client is removable because of a criminal conviction, there's such a thing called post-conviction relief, which you seek in the state criminal court. And that's basically, so you've got a client who was convicted of a crime and now they're deportable because they have that conviction. Post-conviction relief, you're going back to criminal court and you're trying to change the conviction to make it something that doesn't trigger deportability. Right. So that's also a thing. And you may want to have a couple of people in your contacts list who are criminal lawyers who are familiar with how to do that, because that sometimes is a technique of last resort, and it's occasionally successful and can make a world of difference, but it's not an easy thing to accomplish.
And I will say that although that is an option, you really want to make sure that you have someone that's handling it that is also familiar with the immigration side and impact of things. So someone that's kind of like a crimmigration lawyer, handling the post-conviction relief, because it can cause some issues if it goes back to immigration court and the judge says, well, the only reason this was changed was for immigration, you know, purposes, so therefore we still consider it a conviction. And that's a whole nother hairy topic and situation of its own. But it's definitely a best practice to have contacts that not only do the post-conviction relief, but also are familiar with the right way to craft it, so that the immigration court will validate if whatever it is that they're doing. For example, I had one situation where and it was a criminal attorney that he had done some post-conviction, and then the court was saying, well, that was only for immigration purposes, so we're not going to consider that a valid. He had vacated the conviction completely, and they said, no, it's not valid. So not to get too deep into the crimmigration topic, but it's definitely important to have a trusted crimmigration expert or have a resource, you know, to research that.
Yeah, you should be working closely. You, as the immigration attorney, should be working closely with the criminal defense counsel, or find an attorney who's familiar or who practices in both areas. Someone's asked a question in the chat here. I'll give it to Moises. Would administrative closure allow for allow for applying for an EAD, and if so, under what specific category?
So I have, for example, if you have an EOIR 42B pending and an EAD was already obtained, it is pretty common, you know, here where I'm practicing, that even after administrative closure, because since administrative closure is not terminating the case, technically the case is still pending, the application is still pending, so then EAD renewal is possible. However, I'm not sure if the, for example, the 42B was not filed prior to the administrative closure, you might run into some issues.
Yeah, administrative closure just by itself is not grounds for applying. It's not a basis for applying for an EAD. Administrative closure is a tool of, the magic words they always use, a tool of convenience for the court to temporarily take cases off the court's docket, right? So yeah, it's not a basis by itself.
Right. Maybe that's what the question was asking. Yeah.
Okay, well, we've talked about a lot of topics, and this is where we're kind of at the end of our time. We could just keep going on and getting deeper and deeper and deeper into these things. And we'll have, if people are favorably disposed to this webinar, then we'll go deeper into some of the more advanced topics. There's some very advanced topics like aggravated felony analysis under the federal case law and things like that we could go into, but we'll save those for another day. We are going to be putting we'll write a blog post about today's webinar. And Moises, you said that you had a list of resources that you wanted to share. So we will include that with our blog post that'll go along with this webinar.
Absolutely. And I'm really excited to share these. I wish I would have had these resources when I first started practicing immigration law, but I'm happy to do that.
Yes. All right. So look for our blog post to go along this webinar. Well, thanks to everybody who attended. We appreciate you. We appreciate both of our guests here again. And unfortunately, Ahmed had a little technical difficulty, but Moises, thanks again a ton for joining us.
Absolutely.
And thanks here to Chris Williams here, who facilitated the technical aspect of the webinar for Docketwise. All right, everybody, stay safe, have a great week, and take care. Talk to you next time.